Wind chill's 20 below right now, so I'm bundled up. Got some breaking news that happened late yesterday afternoon, basically at the close of the business day at a major appellate court. And it has a decision that is rocking gun control to its core. Oh, they were all crying on Twitter yesterday. And I'm going to tell you all about it. First, I want to thank the sponsor of today's video, and that's Fold AR. Now, obviously, because of YouTube's recent activities, I'm not going to show certain things, but you can see on this little clip here that Fold AR allows you to really get your item compact. And they guarantee that when you unfold that item, it's guaranteed to go back to zero, which is pretty cool. Now, getting something that compact is great for getting from point A to point B without being detected, or for putting it in a pack and stowing it to go hunting, to go hiking, or putting it in your saddlebag on your motorcycle. There's a ton of reasons why I can think of keeping something compact, and Fold AR makes some pretty cool stuff. They're veteran owned and operated, made here in Texas in the USA, and they have a lifetime warranty. Thank you to Fold AR for being a friend of the channel. Guys and gals, you know how to find them. Let's jump into this decision that came down in a 3-judge panel in the 5th Circuit U.S. Court of Appeals, and it is destroying the Karens of gun control. I'm going to show you the case and I'm going to explain it because there's a lot of nuances here. Here we have somebody who's been painted as a violent criminal who had a civil restraining order against him. And the federal restraining order law would ban you from your Second Amendment. Well, that was just called unconstitutional. And what the judges did, the way they broke it down, oh boy, Bruen was a hell of a decision. This is the lawsuit. It's United States of America versus Zachary Rahimi. And let me just break down the description of Rahimi so you know why people are up in arms. But the fact remains, Americans have rights. Between December 20th and January 21st, Rahimi was involved in 5 shootings in and around Arlington, Texas. On December 1st, after selling narcotics to an individual, he fired multiple shots into the individual's residence. The following day, Rahimi was involved in a car accident. He exited his vehicle, shot at the other driver, and fled the scene. He returned to the scene in a different vehicle and shot at the other driver's car. On December 22nd, Rahimi shot at a constable's vehicle. On January 7th, Rahimi fired multiple shots in the air after his friend's credit card was declined at a Whataburger restaurant. Officers in the Arlington Police Department identified Rahimi as a suspect in the shootings and obtained a warrant to search his home. Officers executed the warrant and found a rifle and a pistol. Rahimi admitted that he possessed the firearms. He also admitted that he was the subject to an agreed civil protective order entered on February 5th of 2020 by a Texas state court after Rahimi's alleged assault on his ex-girlfriend. The protective order restrained him from harassing, stalking, or threatening his ex-girlfriend and their child. The order also expressly prohibited Rahimi from possessing a firearm. Now, before I give you the actual definition of the law that took his right away, there are a couple key factors, legally speaking, I want you to be aware of, okay? A civil order, not a criminal conviction. Civil order. He owned a rifle and a pistol. He admitted that he owned those. They were in his residence. And he's not the greatest of people when it comes to criminal history, okay? But be that as it may, this is unconstitutional. Check it out. A federal grand jury indicted Rahimi for possessing a firearm while under a domestic violence restraining order in violation of 18 U.S.C. 922 G8, which provides, "It shall be unlawful for any person who is subject to a court order that A, was issued after a hearing for which such person received actual notice and at which such person had an opportunity to participate, and B, restrains such person from harassing, stalking, or threatening an intimate partner of such person or child of such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child, and C, includes a finding that such person represents a credible threat to the physical safety of such intimate partner or child, or 2, by its term explicitly prohibits the use, attempted use, or threatened use of physical force against such intimate partner or child that would reasonably be expected to cause bodily injury, and to possess in or affecting commerce any firearm or ammunition. Now, Rahimi moved to have this dismissed because this is a civil court order, but when he did this the first time, it was pre-Bruen. So courts upheld this clause in the federal law because he had a restraining order, he possessed firearms, and according to that law, if you have a restraining order, you shouldn't be having firearms. You're banned from possessing those, okay? Well, this is where this court gets it right, and the way they broke it down, it's gonna piss a lot of people off this morning when they're waking up. Now, the court goes into how the Fifth Circuit has a rule, a policy that no court overturns another court unless they absolutely screwed up or they're not in line with a new decision. In this case, it's Bruen. So this court is reinterpreting a previous ruling on Rahimi's case. Look at this right here. Enter Bruen. Expounding on Heller, the Supreme Court held that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects the conduct. And in that context, the government bears the burden of justifying its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Put another way, the government must affirmatively prove that its firearm regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. Okay, we've heard that before. That's the Bruen decision. That's the meat and potatoes of it. And the challenge to this by the government might fluster some of y'all, but I'm going to put it on the screen because you need to know which way the government comes when they try to strip people's rights at any cost. Here this is. Our review of Rahimi's facial challenge to 922G8 is de novo. First, the court addresses the government's argument that Rahimi is not among those citizens entitled to the Second Amendment's protections. Concluding he is, we then turn to whether Section 922G8 passes muster under the Bruen standard. So what they're saying is, he has the Second Amendment rights. So now the rule that he's challenging, we need to make sure that passes the muster of the history and tradition of the country around 1791 when the Second Amendment was adopted. This is where it gets good. According to the government, Heller and Bruen add a gloss on the Second Amendment that restricts its applicability to only law-abiding responsible citizens in Heller and to ordinary law-abiding citizens in Bruen. Because Rahimi is neither responsible nor law-abiding, as evidenced by his conduct and by the domestic violence restraining order issued against him, he falls outside of the ambit of the Second Amendment. Therefore, argues the government, Section 922G8 is constitutional as applied to Rahimi. And to attempt to prove that this federal law that restricts people's Second Amendment if they have a domestic violence restraining order, the government produced three categories of analogical reasoning. Okay, you have to dole down and find stuff that'll make the justices say, look, yeah, this is concurrent with the way things were done back then. And the first set of laws they did were back in the 1600s. So that really doesn't apply to the founding of the country. So that was kind of tossed out very, very quickly. The second set, you gotta love the freaking government. The second set of restrictions were laws that took entire classes of people based off of their skin color or what have you, and barred them from having guns. So they went back and said, look, we did it when we were racist. That was cool. We made sure that slaves couldn't carry guns and Native Americans couldn't. So we could do that here, right? So that was destroyed pretty quickly. And then came the surety laws from the colonial days. Long story short, surety laws, if somebody was in fear of somebody doing harm to them or their property, they could go to court, bring them to court civilly, and that person who they were afraid of doing something or had made a threat that was verifiable would have to post surety to say that I'm not going to hurt them. There's no way I'm going to hurt them. And then their rights would be put back in full effect. They could have their Second Amendment rights again. But the court said there's little to no evidence at all that those surety laws were ever enforced. So that doesn't apply here either. Back to the decision. The government fails to demonstrate that Section 922G8's restriction of the Second Amendment right fits within our nation's historical tradition of firearm regulation. The government's proffered analogs falter under one or both of the metrics the Supreme Court articulated in Bruen as the baseline for measuring relatively similar analogs. How and why the regulations burden a law-abiding citizen's right to armed self-defense. As a result, Section 922G8 falls outside the class of firearm regulations countenanced by the Second Amendment. Doubtless that 18 U.S.C. 922G8 embodies salutary policy goals meant to protect vulnerable people in our society. Weighing those policy goals' merits through the sort of means and scrutiny our prior precedent indulged, we previously concluded that the societal benefits of 922G8 outweighed its burden on Rahimi's Second Amendment rights. But Bruen forecloses any such analysis in favor of a historical analog inquiry into the scope of the allowable burden on the Second Amendment right. Through that lens, we conclude that 922G8's ban on possession of a firearm is an outlier that our ancestors would never have accepted. Therefore, the statute is unconstitutional, and Rahimi's conviction under the statute must be vacated. So the federal law that says you must not have your Second Amendment if you have a domestic violence restraining order has been struck down. And dude, last night, Moms and Gifford and you name it, they were like, if Twitter could cause your screen to cry, then I would have been drowning because it was phenomenal. Now, I'll grant this to you. Was this cat the best dude? Probably not. I don't know him. I didn't read any of the reports of things he did, but just by this court case, he sounds like not the best candidate to be, I guess, trusted, right? But where in the Constitution does it say you must be somebody who has to be able to be trusted to get your rights? It doesn't. And what Bruen did was it returned the way the country restricts the Second Amendment back to the days that said this is how it's done. It's been bastardized for the last 30, 40 years, and the Bruen decision corrected it. This is a huge win for the Second Amendment. And you know what? I really, truly think that come March, when all of those cases in New York about the Concealed Carry Improvement Act and all of the violations of our rights that New York decided to throw in, I think that's going to get destroyed. In my heart, I know it's going to get destroyed because Clarence Thomas is salivating to get it back. And that's going to destroy what's going on in New Jersey and what Gavin Newsom did the day before yesterday and what Illinois is doing. Guys and gals, we are living in a phenomenal time if you are a Second Amendment junkie like myself. And unfortunately, it takes time, right? Which is how this country was designed. A lot of us get caught up in that, oh, it should be struck down immediately. That's not how it works. You know, unfortunately, temporary tyranny is a thing. It's still tyranny, and it's going to get struck down. Let me know what you guys and gals think about this specific case here. Federal law has been called unconstitutional. If you want to stay in the loop with all of the chocolatey goodness that's happening around the Second Amendment and the victories as well as the temporary defeats, then like the video and subscribe down below. Please share it so more people get it. YouTube's doing that crazy I hate the Second Amendment and everybody who makes a video about it thing. So it's on us to help get everybody's channels out from behind the Iron Curtain. So share the videos of those you watch, like and subscribe if you could. Until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. We have it for a reason, guys and gals, and they're not taking it from us. And if I could ask a favor, I'm looking right now. The channel right now, as I'm recording, is at 598,728 subscribers. So if you could help me get over that 600,000 subscriber mark, that would mean a lot. That's a huge part of the goal of me doing this channel. The next is the million. I'd love to do that. Well, we'll see. I'll see you all in the next one. Take care.